If police simply did the search correctly, they wouldn't need exceptions, they wouldn't need a good faith clause to keep their illegally obtained evidence in. This is our last episode this season, Season 2, and in our series on exceptions to the warrant requirement. Thank you so much for your views, your comments, your questions, and for subscribing. We love being part of your Fridays. So having gone through all the exceptions to the warrant requirement, I want to bring us back to a topic we covered briefly before, the exclusionary rule and the good faith exception. We discussed it earlier, so this should be familiar, but let's go a little deeper. Let's look at how the good faith exception turns constitutional violations on their heads, makes the right to be free of unreasonable search and seizure a right without a remedy, and how we can walk back the good faith exception from good enough to good cause and properly executed. My name is Shelley Behan, and this is Fourth Amendment Friday. The judicially created exclusionary rule suppressed evidence that was obtained in violation of the Fourth Amendment. If the police violated the Constitution while obtaining the evidence, sorry about you, it isn't coming in. There was a deterring effect in mind, sure, but there was also the idea that we are protecting the right of the people to be free from unreasonable search and seizure as defined by the law. And things were going along swimmingly until the good faith exception came roaring into court, focusing solely on the idea of deterrence. The good faith exception says that if suppression doesn't fit the goal of deterrence, the evidence comes in, no matter the violation. So now we have moved from the standard constitutional analysis to the officer's mindset. So we can check in with subjective things like whether the officer believed his or her conduct was lawful. There are narrowly drawn instances where the good faith exception makes sense. Relying on a defective warrant, unless it's so defective, like the warrant in Grow, that no officer would ever have relied on it. Relying on a statute that is later overturned, or relying on database errors, like a computer, which says there's a warrant for a citizen when there isn't one. And the situation in U.S. versus Leon was one of those narrow instances, relying on a defective warrant. But the case doesn't stand for the idea that everything now comes in if the officer testifies, oops, my bad. Unfortunately, courts have usually gone that way, and prosecutors try to make defense counsel prove bad faith on the part of the police in order for the court to suppress illegally seized evidence, which is not the standard. We have spent the last 9 weeks talking about a system that has created so many shortcuts for officers. A good faith exception simply shouldn't be necessary. Think about each of these exceptions. In consent, rights are waived. Vehicle and inventory allow full-scale rummaging of the car with or without probable cause. Plain view expands the seizure capability of the searching officer, while CETA expands the searching capability of the seizing officer. Collective knowledge allows officers to pile facts together, and inevitable discovery comes in to save bad searches if there is another way that they were actually working to get there. Why should they need the good faith exception to forgive all the other mistakes that the police make? If police simply did the search correctly, they wouldn't need exceptions, they wouldn't need a good faith clause to keep their illegally obtained evidence in. And this is something that should outrage every citizen. It is only in the rarest of circumstances should a violation of constitutional protections not result in a penalty, because when the remedy disappears, the right goes with it. Courts have expanded the good faith exception to cover more than technical mistakes that rarely occur, and instead excuse sloppiness and assume all officer action is reasonable. If the evidence is admitted anyway, time and again, what is the incentive to follow the Fourth Amendment? The rule becomes conditional, the exception becomes expected. It isn't about fighting for suppression then, it's about tightening up the definition of what is and is not reasonable. Attorneys can attack the foundation for the search. The warrant was bare bones. The probable cause was iffy at best. They can redefine deterrence. Suppression matters and sends a message to the police that the training they received to comply with constitutional standards was not some aspirational idea, it's a minimum. Take a step back and let's pour some Fourth Amendment on it. The exceptions to the warrant requirement have moved us from the strict guidelines of neutral and detached magistrate, oath and affirmation, particularity and probable cause, to the judgment of a police officer at a single moment in time. We have gone from a system built on restraint of government power to one that hands over the reins, points out the shortcuts and the hideouts, and then after watching constitutional chaos unfold, simply says, come out with all your stolen treasure, we forgive you. You meant well, you tried your best. And as for you, citizen accused, quite frankly, the only party to whom the Constitution guarantees anything, sorry about that Fourth Amendment right, sorry about that due process. When the officers kept making mistakes, we created an exception, and then we created another, and then we created another, and then we created a reason to keep the evidence in anyway. and then we called it all reasonable. But that doesn't happen when we as citizens have our eyes open, and when we go into court, and when we demand due process, and when we demand the justice system do what it was always designed to do: protect the individual from the state, and elevate the liberty of the citizen over the ease of the officer. And that does it for this season of Fourth Amendment Friday. Tune in next time when we start Season 3. We'll be taking a deep dive into the future of privacy. Before we sign off for Season 2, I just want to add how grateful I am to be able to share my thoughts about the Fourth Amendment with all of you, and how much I look forward to writing these videos for you. I hope you enjoy them as much as we enjoy making them for you. We absolutely love being part of your Friday. So until Season 3, stay free, stay fabulous, and remember your fundamentals. My name is Shelley Behan. I'm the host of Beyond the Breathalyzer, and your rights are my priority.